This meeting of the Littleton Licensing Authority will come to order. City Clerk, would you call the roll, please?
Authority Member Bradish.
Here.
Authority Member Gunya.
Here.
Authority Member Odell.
Here.
Authority Member Cole.
Here.
Authority Member Mather.
Here.
Authority Member Gallagher.
Present. We do have a quorum. Next item of business is approval of the agenda.
Mr. Chairman, I have a question. Item 8A, refresh my memory why this is on the agenda.
I'm not sure it should be. We had a discussion about that in our last meeting.
We had a discussion on the last meeting. This was one where the manager had the liens on
Right.
her. We had a discussion about it being the manager only, but there wasn't sure it was a manager only, and they were going to clarify it and come back to us. The city was.
Okay, so we're waiting on a response from
The city.
City Clerk's office?
She has filed all the necessary paperwork, but under the statute, we're required 10 days' notice before a renewal hearing, and she didn't do that in that time period. So we need to continue it until until February 13th.
Okay.
So that
I
we
was
can
just
comply with the
questioning why I was
notice,
still
and then
there.
we'll address it at that hearing.
Okay, so it's still going to be continued until next month. Okay.
I'll move that we approve the agenda.
Second that.
All in favor?
Aye.
Opposed? Motion carried. Next item of business is approval of the minutes of our previous meeting. They're rather lengthy minutes. I've read them. I don't have any objections, but
I had a couple of items.
Willie would.
On page 2, under paragraph 4, or heading 4, it's missing who actually made the motion and seconded the motion.
That's because we kind of got off track on that. I rewatched it today to make sure.
Okay.
Because we actually made a motion to add fresh nail wax and dry bar back on, but we never actually made a motion to accept or second those minutes.
Okay. Do we need to approve them now?
Yeah, can we go ahead and approve them now, then?
Okay, so I'll move now to approve the minutes of the November 14th meeting as we discussed at our previous meeting.
Second the motion. All in favor?
Aye.
Opposed? Motion carried. Thank you.
And then on page 5, the motion regarding Toad Tavern, it says that there were 3 members listed as yes and 2 members listed as no, but it says motion carried 5-0. So I didn't know if the name or the number was off.
On page 5?
At the very bottom of page 5, spilling onto page 6.
Top of page 6.
Actually,
Oh, okay.
it's here. And then if you look here, it is 5-0.
I believe I did vote yes, so I think my entry is correct.
Castle, that's Toad there. Oh, over here, okay.
5-2.
What
I think
I'll make those corrections.
I'm almost
Okay.
sure it was 5-2.
Okay. So those are the
Other names should be there.
yeah.
And I have a correction on, oops, are we done with that one?
Yes.
I have a correction on page 8. It states, Authority Member Mather, me, stated that just because there was no further discussion on the motion, and it should read, it could not be assumed that those other items would not be discussed at a show cause hearing.
Which paragraph you in?
I'm on the 4th paragraph. Should say it could not be assumed.
Thank you.
And what would you like to correct that to say?
She wants the word not.
The not, It cannot be assumed that just because we didn't discuss an
Okay.
issue doesn't mean that we aren't going to be addressing it at a show cause hearing.
Any other observations, questions?
I'll move that we approve the minutes as amended.
Second that.
All in favor?
Aye.
Aye. Opposed? No. Motion carried. Before we proceed, I want to ask the people in attendance if you're planning to speak at this hearing. There's a sign-up sheet at the front desk that we ask you to sign in. Thank you. Next item of business is item 5A. It's a renewal hearing for AMF Bowling Centers Incorporated, doing business as AMF Broadway, 5485 South Broadway.
This is agenda number 5A, scheduling a liquor license renewal hearing. The issue before the authority is whether to schedule the renewal application for AMF Bowling Centers, Inc. for a public hearing. I would ask that you accept into the record Exhibit A, proof of notice to the applicant, Exhibit B, the authority communication, Exhibit C, the liquor license renewal application, and Littleton Police Report memo.
I'll move we accept Exhibits A through C.
I'll second that.
Thank you.
City Clerk, would you poll the authority?
Authority Member Bradish?
Yes.
Authority Member Gunya?
Yes.
Authority Member Odell?
Yes.
Authority Member Cole?
Yes.
Authority Member Mather?
Yes.
Motion is carried.
Routine liquor license renewals are generally handled administratively under Section 3216 of the City Code. That section states that the chairperson of the authority is authorized to grant renewals so long as no information regarding alleged violations of the Colorado Liquor and Beer Codes or Amendment 20 of the Colorado Constitution or violations of this code have been referred to him or her by the police department or otherwise. Pursuant to Section 3B of the Licensing Authority Guidelines, the Littleton Police Department renewal report or any other information obtained from other city departments indicates to the city attorney probable cause to believe there is good cause to refuse to renew. The city attorney has discretion to place the renewal application on the agenda. The issue before the licensing authority shall be whether to schedule the renewal application for a public hearing. The licensing authority shall be provided with the renewal application, renewal report, and any other information upon which the city attorney based its decision to place the renewal application on the agenda. No testimony shall be taken, and the licensing authority shall base its decision solely upon the information provided. If the licensing authority decides to schedule the renewal application for a public hearing, the renewal application shall be scheduled for the next public hearing date following notice as required by CRS 1247-302. The chairperson shall be authorized to proceed with approving any renewal application not scheduled for a public hearing by the licensing authority as part of this procedure. So you'll see attached to this is the renewal report, including the reference to the two Littleton Police Department police reports for AMF Bowling Centers, Inc. Staff recommends that the authority not schedule the renewal application for this licensee for a public hearing and authorize the chairman of the authority to approve the renewal application in accordance with 3-2-16.
Mr. Chairman, I don't see that the two incidents that have been reported rise to the benchmark where this renewal could not just be approved administratively. So I would like to move that the renewal application for AMF Bowling Centers, Inc. be approved administratively by the chairman of the authority without the need for public hearing thereon.
Second.
Second.
I'll move we accept Exhibits A through C.
I'll second that.
I'll second that.
I'll second that.
Second.
Any discussion on the motion? City Clerk, would you poll the authority, please?
Authority Member Bradish.
Yes.
Authority Member Gunya.
Yes.
Authority Member Odell.
Yes.
Authority Member Goal.
Yes.
Authority Member Mather.
Yes.
Motion is carried. The application will be approved administratively after this meeting. Next item of, let's see, we're going to skip over 8A, fresh nail at Aspen Grove. Isn't that what we decided?
Yes, it's going to be continued to February 13th.
Okay. Next item of business, item 9A, Home Field LLC DBA All-Star Sports Club, 5151 South Federal Boulevard, Unit A.
This is agenda item 9A, a probable cause hearing for Home Field LLC doing business as All-Star Sports Club.
It's really hard to hear you, Kristen.
I'm sorry, I
I know
have
you're
laryngitis.
not feeling well, but
I'm trying as hard as I can, so I'll get closer to the mic. I'd ask that the authority accept into the record Exhibit A, proof of notice to the applicant, Exhibit B, the authority communication, Exhibit C, the Littleton Police Department Report 2012004346, Exhibit D, summons 661538, and Exhibit E, proof of notification to applicant regarding expired liquor license.
I'll move that we accept exhibits A through E.
My second.
All in favor?
Aye.
No opposition?
Okay. The issue before the authority is whether there is probable cause to believe that Home Field LLC doing business as All-Star Sports Club violated the Colorado Liquor Code and Littleton City Code and should be scheduled for a public hearing to show cause, if any, why its license should not be suspended or revoked. This matter comes to the authority as a possible violation of the Colorado Liquor Code and Littleton City Code by the licensee following an incident on August 11, 2012 at approximately 5:50 p.m. Possible violations of the Colorado Liquor Code and Littleton City Code include Regulation 47902, Regulation 47904A, Regulation 47904C, Colorado Revised Statute 1247301-4A, and Littleton City Code 3-2-7. Those are contained in the authority communication. I'm not going to read them here because of my voice. Attached is case report 2012004346. Section 3C of the Licensing Authority Guidelines states that the authority must consider the probable cause evidence presented, and based on the totality of the circumstances, the authority must find there is a reasonable belief that a violation has occurred based upon reliable information. Staff recommends that the authority find that probable cause exists sufficient to set this matter for a show cause hearing. Show cause hearing should be set in March with a March 13, 2013 hearing date to allow for a preliminary hearing to be held in February. A February 13, 2013 hearing date in accordance with the licensing authority guidelines.
So is this business still open?
This business is not still open is what is our understanding. They have not filed their renewal.
Okay.
they have not filed for renewal?
No.
I
So Colleen did reach out.
When does the license expire?
December 18th.
Yeah,
Of last
So,
year.
right.
So it's expired right now.
yeah,
So
and
they have
haven't
no
filed?
license.
No, but they
Business
have,
in the
they
story.
technically have
End
40,
of story.
they
But they-
technically
wait.
have 45 days,
In which they could file?
I thought it was 90 days.
90 days.
But we didn't want to not, we wanted this process to move along because they could still come in and renew it, and then,
Fine.
and then we would sort of be in a quandary, so we wanted to move forward with this.
And then it says on page 6 of the report that Subin, who I believe was the manager, did confirm that the bar has been closed for several weeks. So, okay.
And
Just wanted to
it is,
confirm.
I verified that myself, it is closed. So do we need to go through the motion of scheduling a show cause? And then
I'd like us to move forward on this. We have tried to contact them. We're hoping that we can get them to just
Okay.
bring the license in, and then all of this will
Well, and I see the reason for that, because if we take action on this, then this gentleman will have a hard time getting a license in the future.
I don't think there's any doubt, based upon testimonies of the bartender and the server and the patron, that there's reasonable belief that a violation occurred, and I think we should move forward on it.
Well, and also, some of it is, he said, she said. I mean, I'm not sticking up for the bar owner. It sounds like he's flouting every rule that the revised statutes has. But some of that could be disgruntled employee statements too. So I think we probably need to hear his side of the story, and I believe we have probable cause to bring him in.
Yeah, that's the big reason why we need to have the hearing is because there's facts that are in dispute, and we need to bring that out into the open and discuss it. And I would be in favor of the motion if there were one. As a matter of fact, I'll make the motion now. I move to find that there is probable cause to believe that Home Field LLC DBA All-Star Sports Club, 5151 South Federal Boulevard, Unit A, Littleton, Colorado, on August 11, 2012, at approximately 5:50 p.m., did violate the Colorado Liquor Code and Littleton City Code, specifically Regulation 47-902, Regulation 47-904A, Regulation 47-904C, CRS 12-47-301, 4A, and City Code 3-2-7. Based on said findings, I move that a public hearing be set for the 13th day of March 2013 for the purpose of considering the status of said public hearing be set for the status of said license, wherein the above-mentioned licensee may be present to show cause, if any, why its license should not be suspended or revoked, and further, that notice of these findings and hearings to show cause shall be forwarded and served to 5151 South Federal Boulevard, Unit A, in accordance with the provisions of state law. I move that the preliminary hearing, if necessary, be set for the 13th day of February 2013 for the purpose of considering a possible stipulation, if any, between the licensee and the city of Littleton.
I will second your motion, Mr. Chairman.
Please poll the authority.
Authority Member Bradish?
Yes.
Authority Member Gunya?
Yes.
Authority Member Odell?
Yes.
Authority Member Cole?
Yes.
Authority Member Mather?
Yes.
Motion is carried. Next item, 10A, T&K Smith Enterprises Incorporated, doing business as the Castle Bar and Grill, 6657 South Broadway.
This matter comes before you tonight on a preliminary hearing. We have not reached any sort of factual or sentencing stipulation, so we're asking the matter be set for show cause hearing next month.
It's already set, so we can just move on to the next item on the agenda.
And I move that we move forward to the show cause hearing on Wednesday, February 13th.
I second the motion. Discussion. Poll the authority, please.
Authority Member Bradish?
Yes.
Authority Member Gunya?
Yes.
Authority Member Odell?
Yes.
Authority Member Cole?
Yes.
Authority Member Mather?
Yes.
Motion is carried. Next item of business, item 10A, Ned Kelly Incorporated, doing business as Ned Kelly's Irish Pub, 5686 South Sycamore Street.
Good evening, Mr. Chairman, members of the authority. May it please the authority, John Stonebreaker, appearing on behalf of Ned Kelly, Inc. The owners and general manager of Ned Kelly are present and before the authority this evening, and I believe we have a stipulation.
On behalf of the city, we would present into the evidence Exhibit A. I don't believe it has been officially marked, but we'll mark it as Exhibit A, the stipulation agreement in order, and I believe that all license authority members have received a copy of that.
I'll move that we enter Exhibit A, the stipulation agreement in order.
Second.
I didn't hear your motion.
I move that we would enter it as an Exhibit A. Just meaning
The stipulation.
accept it into the record.
All in favor?
Aye.
Aye.
Essentially, what is being presented to the authority this evening is a stipulation to, a partial stipulation to the facts. What we have agreed upon is that on September 29, 2012, between the hours of 10:30 p.m. and 12:32 a.m., the licensee failed to report unlawful, disorderly act and/or conduct committed on the licensee's premises. These facts, as summarized, would constitute a violation of Littleton Municipal Code 3-2-11A2. In exchange for the agreement to stipulate to the facts, the city agrees to dismiss the remaining charges, which would be Littleton Municipal Code Sections 3-2-10F, sale to intoxicated persons, Colorado Revised Statutes Section 1247-901, and Regulation 47-900. No other agreements or stipulations have been reached as to any sort of penalty that will be imposed in this matter. We're presenting this stipulation to the facts, to the authority, and asking that you accept it and then proceed forward to argue for penalties.
Let me see if I understand correctly now. The stipulation does not include a penalty.
That's correct.
If the authority accepts the stipulation, are we giving up our right to impose a penalty?
No.
All right.
Basically, what we're doing is we've reached an agreement as to the facts so that an actual hearing would not have to be conducted as to whether or not what facts are found in this matter. And then now we're turning it over to you to decide what the actual penalty would be.
Thank you. Mr.
Mr. Chairman,
Stonebreaker?
very briefly, I believe the stipulation's been correctly stated by the city attorney's office, and I think the city might have some suggestions on penalty, and so do I.
What would your suggestions be?
I think the city gets to go first.
Should we, should we make a motion first to accept the stipulation before we talk about? So I would move that we accept the stipulation, which is Exhibit A in this instance, the stipulation of facts.
I will second that.
Would you poll the authority, please?
Authority Member Bradish?
Yes.
Authority Member Gunya?
No.
Authority Member Odell?
Yes.
Authority Member Cole?
Yes.
Authority Member Mather?
Yes.
Motion is carried.
For the record, I voted no because we normally do not accept stipulations after the preliminary hearing.
This is the
This
preliminary.
is the preliminary.
Right, that's
This is the preliminary hearing.
stand corrected.
Yeah.
The motion is still carried. All right, now the discussion moves to penalty. I believe the guidelines for the licensing authority in this case would be 5 days with 3 days held in abeyance and 2 days served. Is that correct?
That's correct, and a fine can be imposed in lieu of an actual suspension. That would be the city's recommendation tonight. There appears to have been no prior violations, which would make them eligible for that first offense recommendation under the guidelines and under conduct of the premises violation. The city, in reviewing this and making that recommendation reviewed the list of possible mitigation and aggravations that could occur or be present in this case that would justify maybe looking at either a lighter recommendation or a more stringent recommendation. And based upon what has been presented in the police report, we are pretty comfortable with the 5 days suspension with 3 held in abeyance and 2 actual suspension, and we would recommend a fine in lieu of an actual suspension. The parties that were involved, as you are aware, in the police report, some of them were fairly intoxicated. We had 2 different groups here. The one group that is made up of the Bruces, the Kings, and the Howards, out of those 4, one, Craig Bruce, he blew a .160. He, according to the officer, was intoxicated. His speech was slurred. His eyes were glossy. He lacked coordination. Those group of people, they had indicated to the officer that they were actually drinking at the tavern and then moved down the street to Ned Kelly's. The other group of individuals, Timothy Charles and Autumn Stevens, appears from the police report had been at Ned Kelly's the entire evening. The bar tab was collected from Ned Kelly's. It looks like they were there from approximately 8:30 p.m. to 12:18 a.m. The bar bill was a Jägermeister shot, 2 Bud Lights, an apple martini, 5 green teas, and 4 Captain Morgans. Mr. Charles blew .112 PBT, and Autumn Stevens blew .202. Autumn Stevens, as relayed from the police officer, her balance was unsteady, her speech was slurred, and she had an odor of alcohol. There was an initial incident that occurred inside the bar where the 2 groups had words, and Mr. Bruce ended up getting pushed into the table and cut his arm. And then a second incident occurred outside the bar across the way in a parking lot where Ms. Stevens and Caitlin Bruce got into a fight. One of the city's biggest concerns is the level of intoxication of Ms. Stevens. She was fairly intoxicated and was not contacted right away. She, in fact, left the scene, and we believe she went home and then returned. The other concern that we have is this was not reported to the police, to the best of our knowledge. So the incident inside, that was never reported to the Littleton Police Department. So due to the level of intoxication, the fact that it was not reported, we would feel comfortable asking the authority to remain within those guidelines.
I have a question, a couple. The green tea, those are alcoholic drinks?
That's my understanding.
Okay. And Ms. Stevens, did she submit to a portable breath test?
She did. I apologize for not saying that earlier. It was .202.
But she had left the scene and gone to her home and then returned?
That's our understanding, is she left the scene
So
after
she
the
could have
fight.
consumed alcohol at home during her absence, is that correct?
I have no way of knowing
Yeah,
that.
nobody has any way of knowing. Okay. That's all I have.
And again, can you just review for me again the city's recommendation?
City's recommending 5 days suspension with 3 held in abeyance for a 1-year period. The 2 days of actual suspension, we would recommend that would be converted to a fine in lieu of the 2 days being suspended.
This is the first offense for this licensee, is it not?
That is correct.
Now, a fine in lieu of suspension, is that a one-time thing? Like we could give, say we're going to do a fine tonight, and then if there's another offense in 1 to 5 years, there's no more fine. It's a one-time thing, isn't it?
It's within 2 years.
That's correct. Typically, what our guidelines and the guidance under the state statute is that you would look back on a 2-year period. If they had a clean record within that 2-year period, they would be eligible for a fine in lieu of a suspension. Our guidelines definitely support that, and it seems as if a first offense, a fine in lieu would be applicable. A second offense, maybe not. So,
I have another question. Would that fine include the 5-day period or only a 2-day period?
only the 2-day period.
And then we would still have 3 days held in abeyance?
Correct.
Yes.
I'm asking, we haven't fined anybody before, so,
Oh, there's a first for everything.
yeah.
Mr. Chairman, if I may very briefly, I'd like to make a few points about penalty. I'm going to ask the board to take a look at the stipulation, and I think the important part about the stipulation is the only violation that is there doesn't have anything to do with sales to visibly intoxicated persons, which were charged but dropped, doesn't have anything to do with conduct of establishment, which was charged but dropped. The only thing that's in the stipulation is that the licensee failed to report essentially conduct committed on the licensed premises. So I'm going to ask the board to think less about the facts relating to visibly intoxicated persons. I think Mr. Gallagher makes an excellent point. The persons who were tested were absent from the premises for any number of hours before they were actually tested, and who knows what could have occurred during that period of time. We just don't know what was consumed off the premises. So then when we say to ourselves, the only thing that's here is this failure to report conduct on the premises, then if we go over and look at the guidelines, which the city was kind enough to provide me, the guidelines that talk about 5 days, 3 days, 2 days fine are talking about certain specified violations. Basically, those are the violations that we deal with all the time. Sales to minors, sales to visibly intoxicated persons, those types of violations. What I'm saying to the board is this very, very small, relatively insignificant violation to which my client has stipulated, which is this failure to report, is not actually covered in the guidelines. So I'm going to suggest to the board that the guidelines really don't apply here because the conduct to which my client is stipulated is beneath or lower. It's not covered by the significant violations that are in the guidelines. What I'm going to suggest to the board is as follows. I think that the proper penalty should be 2 days held in abeyance for a period of 1 year, and that's just it. What we are talking about here in the stipulation is failure to pick up the phone and call the police, and that's really all that we're talking about. There's no other violation that's here that would pull this case into the guidelines that are promulgated by the city. My client is essentially on notice that when certain conduct occurs on the subject premises, he's to pick up the phone and call the police. My client has received that message loud and clear. I am also going to ask the board to consider that my client's been in business in Littleton for 4 years, no violations of any kind or character before this evening. And I'm going to ask the board to consider the fact that the general manager, Mr. Witkowski, is currently carrying a valid tips card. He was at the time of this particular incident. His tips card expires in 2014. The training that he has, he's at the establishment virtually all the time, is certainly being the way that this operation is run and being supervised. I'm also going to ask the board to consider that my client, under a different company but the same ownership, operated an establishment in Denver for 5 years, from 2005 to 2010, and had no violations in Denver during that period of time. So my client has a long, successful history, and again, I'm going to ask the board to consider that the violation that we're talking about isn't actually what's in the guidelines. What was stipulated to is, frankly, a relatively minor infraction.
Councilor, you make some very good points. However, you keep coming back to the fact that it's not in the guidelines. I believe you've omitted to Regulation 47-900.
Sir, I did not. If you look at the
Look at page number 9.
Yeah, what I'm talking about is the stipulation. The stipulation, what is in there, is simply the Littleton Municipal Code. Sir, that was done on purpose. The stipulation is just to the violation of the Littleton Municipal Code. There is no stipulation to the violation of the state regulation. And that was done on purpose The state regulation does not impose the reporting requirement. The reporting requirement is only imposed by the Littleton Municipal Code. So the citation relative to the failure to report is merely or simply the municipal code violation as opposed to a violation of the state statute.
But the guideline covers the Littleton Code.
Well,
I'm looking at page number 9,
okay,
section 4A. And it says conduct of premises, regulations 47-900,
right. But if you look at that list,
which is the Littleton Code, is it not, sir?
No, that's the Colorado Revised
no,
Statutes.
sir, I believe the reg is
That's
in
the
the state
CRS,
statute.
yeah.
Yeah, so we're talking about two different bodies of law. The matters that are specified in the reg are more serious. And the point that I'm making is those more serious matters that are in the guidelines are not what are in the stipulation. The stipulation is beneath or less serious.
So the owner bartender is tips trained. Are the other bartenders?
Yes,
Yeah,
they are.
part, what are you saying?
You know, this
On the
wasn't
part
exactly
that
a small,
specifies
insignificant
something.
incident. Someone was injured.
Well, and yeah, we don't want to diminish the importance of notifying the local police department. We have a pretty small-knit, close-knit community here, and we want to stress the fact that if there is trouble in any of the taverns or establishments in town, that the police should be notified.
And Ms. Mather, Mr. Gallagher, I think that's an important point, and that's why it's in the stipulation.
Okay.
And I do think some penalty and the warning and the process is part of the whole situation. So I actually agree with you. However, my point is the violation that we're stipulating to doesn't reach the level of what's in the guidelines.
And I guess my challenge would be that the guidelines don't say there's no resolution leading off to it saying we found these things to be most important and didn't find others. I mean, so I do think you're making a bit of a leap, and I don't want to. I guess I would challenge the distinction that failure to report is not an important part of our code. Again, like Tony said, I mean, you know, an altercation at a bar where a lot of people are intoxicated could lead to a lot of other people being unsafe. I think rises to the same kind of level as the failure or the harm to an individual who would be overly intoxicated, even to the, you know, sale to a minor. So I guess I would challenge the idea that it's not major, and the idea that because it was left out, therefore the council didn't believe that it was.
Indeed, the rationale behind that is that if the owner or a manager, someone in that establishment, calls the police, it keeps the situation from escalating. When you don't get the police there early, situations typically can escalate. So I do think it's a very wise and important part of our city code in regard to liquor licensing.
Yes, and I'm not trying to minimize it. Mr. Cole, Mr. Odell, I actually agree with what you're saying with the exception of the reference to the guidelines. The guidelines say the actual sanctions imposed may vary from the guidelines set forth herein depending on the circumstances of each case. So what I'm saying is, since the circumstances of this case really aren't in the contemplation of the guidelines, there's a logical place for us to go, which is with a little bit smaller penalty.
And if the city may, the guidelines were developed with conduct of premises, Regulation 47901, and with the Littleton City Code being contemplated under that entire act. They mirror each other, with the only exception in the City Code, it talks about an affirmative duty to report. So I think this argument, we're arguing semantics. The guidelines do support this particular situation. The second thing I'd like to point out to the authority is under Littleton City Code 3214, That's the list of aggravation and mitigation that you can consider. The one thing you can consider is all circumstances surrounding a violation, and that's in subsection G. And I think that's important, too, that while we may have pared this down to get a factual stipulation, you can consider the entire case, not just the one issue regarding failure to report.
I do want to make the point, I think that it's important to note that an altercation occurred, not just in the bar, but again, outside in the community. And I think that's important because I understand what you're saying about, the stipulation was to that issue. But again, if the police had been called there, they most likely would not have ended up in a parking lot, out down the street, which, again, I think that's the point. Now, I would say, so I would consider that an aggravating factor here. I do think that it's important to note that there have been no violations. I would probably come somewhere in between the city and the licensee at the moment.
I think that's a fair judgment.
Since it was correctly pointed out to me that this is a preliminary hearing,
No, this is a preliminary hearing, but they've made a stipulation.
but they made a stipulation. If we propose a penalty, do they have to agree to the penalty? And if they don't, does it warrant
Necessarily.
show cause?
I understand, not necessarily.
No, I mean, we have found a violation occurred by stipulation.
Right.
So.
Yeah.
But by stipulation.
We're
but
at the
they have not
penalty
agreed
phase
to-
now.
But they have not agreed to a stipulation penalty. So if we propose a penalty, do they have to agree to it as a stipulation? Or does it go to a
I
show
don't believe
cause?
so, no.
I would say that's a question perhaps for Deputy City Attorney. Would your legal opinion be that this stipulation is that they agree as long as we don't consider the others, and we are looking simply at the failure to report, that they have, in essence, agreed to the penalty phase and accepting that in this stipulation?
Right, they've agreed that they could not reach an agreement on penalty, and so they're placing it before you to put the penalty in place based on the facts stipulated, which is just a violation of, the failure to call, the failure to report, 3210F. No, sorry. 3211A2.
So
And Mr. Odell, I
Answer
would
is
tend to
any
agree with
penalty
the city
we
attorney. I think we're stuck with the stipulation.
Okay.
any penalty we impose is subject to their approval is the bottom line of what you said.
No.
I got it exactly the opposite of what it is.
Mr. Stonebreaker, would you be against 5 days with 4 days held in abeyance?
That's not my suggestion.
I understand it's
don't
not your
think I have
suggestion.
an
Would you be
approval.
opposed to it?
Well, if I could pay the 1 day with a fine in lieu, I would not.
You would not be opposed, you mean?
Well,
Right. No, I know, but
I'm trying to be fair.
I know. No, I
Mr.
understand.
Cole.
I wanted to make sure that's what you meant. Okay.
Yeah, as long as I could take the last day with a fine, I think, it would be hard for me to sit here and argue that that's wrong.
Okay.
And, frankly, at that point, it's the board's judgment. I'm not going to have a lot of flexibility.
Well, what's the board think?
I'd be inclined to go along with that, 5 days and 1 day served.
5 with 1 day?
What about a fine?
And they have the ability to pay for that 1 day with a fine in lieu.
And your justification for that,
I think it's reasonable,
based on?
based on the stipulation and based on their record and based on my judgment that that's a valid penalty.
I think the fact that they have had no prior violations is certainly a mitigating factor here.
Yeah, that's my rationale too.
An addition mine would be that I assume that you're not anticipating not reporting again. You said the message is loud and clear. Therefore, I assume the 5 days is simply an enforcement that you're going to do what you intend and believe will happen anyway.
Yeah, and Mr. Odell, frankly, my client has gotten the message. So I think that's a fair statement.
Any further discussion?
I don't have any more questions.
Do we have a motion?
I'll move that we impose a penalty of a 5-day suspension with 4 days held in abeyance
For a year.
for a year, and allow the 1 day served to be, allow a fine to be paid in lieu of the 1 day served.
I second the motion. Any discussion among the members?
Just one question. As far as that fine goes, it's 20% of your alcohol sales for a day. My question is, what day are we fining them for? Is it a Monday or a Saturday or?
What day did this
There's
occur on?
a calculation that the city has, I believe.
We have to pick a day for the city to operate off of. We pick a day for the 1 day suspension, and then we.
Well, we have to do that.
Yes, and then we hold it in abeyance for 45 days to give the city time
Okay.
to collect the fine.
So we still have to come up with what day would the suspension be served?
Is that a separate motion, or is that part, does that need to be part of?
It's usually a part of the motion.
Okay. Did we have a second? We haven't yet.
Authority Member Bradish, seconded.
Oh, okay.
Amend it.
Yeah, so, well, do you mind if we proceed
I
to
do, yeah.
discussion? I'd be interested to hear what the authority thinks, and then I'd be happy to amend or offer a new motion. And the reason I say that is because we haven't yet done this, so.
I have nothing else to add. Do you have something to add?
Well,
We need to set this.
right, we need to set the date, which there's going to be a big difference between a Tuesday and a Saturday. So, like I said,
Does the city have a recommendation?
yeah, does the city have a recommendation?
What night did this happen? What night of the week?
Okay.
Does the licensee have a recommendation?
Well, if the city had a recommendation, it would definitely be a Friday or Saturday night.
A busy
Okay.
night. What night of the week is usually your busiest night?
Friday and Saturday.
What night's skirt night? So is that busier than the other nights?
Let's just pick a Friday and get done with this and move on. We've got a lot of business.
26th of January is a Saturday.
Who's got a calendar?
Earl
Earl
does.
does and I do.
Earl's saying the 26th, which is a Saturday. Or January
Why do you pick a
25th,
Saturday?
which is a Friday? I kind of lean towards the night it happened, which is a Friday.
Okay, Friday's the 25th, 3 weeks from this Friday.
Or Super Bowl Sunday.
No.
Oh, no, that's,
Yeah, that might be. I could certainly see a logic in it being applied on the night it happened. I think that it applies some kind of logic to the situation.
Yeah, I agree.
I don't have a preference for the date, so if you'd like to add that to the motion, I'll vote for it.
So you all need 45 days?
so our day of abeyance is, we're looking at January 25th.
No,
But
Yes.
we're gonna charge,
the date of
Suspension.
serving.
The date of suspension.
right,
And that's January 25th is a
whatever they
Friday.
make on that day.
20% of what their alcohol sales.
That's right.
And we have 45 days after that date to collect, to figure out what that amount is, and then they have 10 days after that to pay it.
Okay.
Okay.
So I'll amend or make a new motion that the penalty for Ned Kelly Inc., doing business as Ned Kelly's Irish Pub, be a 5-day suspension with 4 days held in abeyance for a year, and that the 1 day that they be able to pay a fine in lieu of serving the 1 day, and that day be on January 25th.
I second that motion.
Any further discussion? City Clerk, please poll the authority.
Authority Member Bradish?
Yes.
Authority Member Gunya?
Yes.
Authority Member Odell?
Yes.
Authority Member Cole?
Yes.
Authority Member Mather?
Yes.
Thank you, Mr. Chairman, members of the board. We appreciate your time and attention this evening, and we will do our dead level best not to appear before the board under these circumstances.
Would prefer not to see you come before us again, Mr.
Thank you.
Stonebreaker.
Yes, sir. Thank you.
Thank you.
Next item of business, item 10C, a preliminary hearing for Toad Tavern Incorporated, doing business as Toad Tavern, 5302 South Federal Circle. We have, I believe, a stipulation.
We do. The city would submit Exhibit A, the stipulation agreement, in order to the authority.
I'll move that we enter Exhibit A, the stipulation agreement and order, into the record.
We have a second?
Second the motion. All in favor?
Aye.
On behalf of the city and the representative from Toad Tavern, we're presenting this stipulation. Essentially, the stipulation agrees to the facts that on November 23rd, 2012, at approximately 6:34 p.m., the licensee permitted the loitering of an intoxicated person upon the license premises, which resulted in unlawful or disorderly act or conduct upon the licensee's premise. These facts, as summarized, would constitute a violation of the Littleton Code 3-2-11A2, conduct in establishments, and a violation of Regulation 47901. In lieu of this agreement to the facts, the city is agreeing to dismiss Littleton Code Section 3-2-10F, sale to intoxicated persons, and Colorado Revised Statute Section 1247-901. As far as a penalty recommendation, licensee and the city agreed to a 5-day suspension with 3 held in abeyance for a 1-year period, 2 days of actual suspension, and we're recommending a fine to be paid in lieu of the actual 2-day suspension. The city has discussed the case, the aggravation and mitigation, with the representative from the Toad Tavern. As the board may be aware, there was a prior violation approximately 4 years and 2 months ago out of the Toad Tavern. The city has taken that into account in reviewing and agreeing to the proposed penalty stipulation. We've also taken into account the facts that are presented in the police report. This case is somewhat different than the last case that we just heard due to the level of the disturbance and also the level of intoxication. Not all parties were intoxicated. One individual, Johnny Younger, was intoxicated. There was an argument within the bar. Johnny Younger hit a glass out of the other gentleman's hand, which caused the glass to break. The situation continued outside, where Johnny Younger kicked the bumper of Randy Mooney's car. Per the bar and the statements made to the officers, Johnny Younger was sold 2 beers and a shot. He drank one of the beers and the shot, but did not finish the second beer. Per the officer, Johnny Younger was intoxicated. He had trouble keeping his balance. The officer felt that he was obviously intoxicated before he entered the bar. Apparently, during the investigation, they determined that Johnny Younger had been drinking at a possible another location.
So just to clarify, in this case, the penalty is included in the stipulation?
That is correct. So on behalf of the city and the licensee, we'd ask you to review this and consider accepting the entire stipulation.
I don't see a problem with it. Just got to pick some nights.
I would agree. Is anyone from the licensee?
Yes,
Would it-
there.
Would you all like to speak?
Would you like to
Would you
speak?
like to?
I don't have any
I don't-
questions.
I don't
I
think
think
so. Thank you.
the matter is for the board to decide whether to accept this stipulation, including the penalty. And I don't have a problem with it.
We need to figure out what dates for the fines.
Well, we have
Ken,
to,
what
we
days
have to,
did this happen? What day of the week was this? Yeah. Wait, wasn't there something about a football game?
Saturday, I think there was a college football game being played.
That was a CU football game, wasn't it? Yeah.
Friday.
November 23rd was a Friday,
Yeah.
and why had I see a football game on Friday?
Yeah.
Oh, it's right after Thanksgiving. Oh, yeah. Yeah, they got creamed. I probably shouldn't comment. I went to the CU game that day.
you probably shouldn't.
I would think perhaps we could either do a Thursday, Friday and have them consecutive, or do a Monday, Friday, being, one day is on the day it happened and another day is on a less busy day. I don't know.
Why don't we just do the 24th and 25th of January and Thursday, Friday? I think that's easy, cut and dried, and fair.
I agree. January 24th.
24 and 25.
Do you have any events those
25th.
nights? Do you have any events the night of the 24th and the 25th of this month? Yeah.
Yes.
Okay.
Are those dates
Well,
acceptable?
but we're doing the fine instead of the actual suspension, so, yeah.
I agree with Thursday and Friday night.
Any further discussion? City Attorney have anything to add?
No.
Time for a motion.
Go ahead.
Go ahead.
No, go ahead.
I move that the Littleton Licensing Authority accept the stipulation as presented with a suspension for the purpose of calculating fine in lieu of suspension be between on January 24th of 2013 to January 25th of 2013.
Second.
Discussion? Poll the authority, please.
Authority Member Bradish?
Yes?
Authority Member Gunya?
Yes.
Authority Member Odell?
Yes.
Authority Member Cole?
Yes.
Authority Member Mather?
Yes.
You understand the penalty, gentlemen, and we don't want to see you in the next year at least. Thank you.
Well, I don't mind seeing them at the CU game.
I have a question for the city clerk.
Yes.
Excuse me. Will we be informed of how much these fines work out to be?
I would believe so.
Okay. I just am curious.
Just as a note, if they have to not be less than 200, nor more than 5,000.
Yeah,
Right.
that's in the stipulation also.
Be a heck of a night.
That'll get you for Tuesday night.
Next item of business is 11A, Tavern Littleton Incorporated, doing business as Tavern Littleton, 2589 West Main Street. I believe we have a stipulation in this matter also.
Label it exhibit.
Yeah. Absolutely.
The licensee is stipulating to the violation in paragraph 1 above, which was violation of Littleton Municipal Code, Section 3-2-10, sale to intoxicated persons. Also, Littleton Municipal Code, Section 3-2-11A2, conduct in establishments. Littleton Municipal Code, Section 3-2-11A4, standards of conduct. And Colorado Revised Statute, Section 12-47-901,
Excuse
and
me, Bill?
Regulation 47-900. Is that correct? They stipulate
We
to that
need
entire
to
thing?
enter the exhibits in first before we go through that.
Oh,
And we would like to list the
Exhibit,
stipulation as
A
Exhibit
through
K.
K.
So on behalf of the city, we'd ask that Exhibit A, proof of notice to applicant, Exhibit B, proof of publication
Through
of
J,
hearing.
I'm sorry. Has everyone had a chance to look at Exhibit J?
No, but I think this will be K. I think she's.
Okay.
Correct.
So Exhibit A, proof of notice to applicant, Exhibit B, proof of publication of hearing, Exhibit C, proof of posting of premise, Exhibit D, authority communication, Exhibit E, Littleton Police Department, police report 20120053335, Exhibit F, Littleton Police Report 20120053004, Exhibit G, Littleton Police Report 20120053005, Exhibit H, Littleton Police Report 20120053007, Exhibit I, list of subpoenas issued, Exhibit J, public hearing roster, and Exhibit K, which is the stipulation agreement and order. Authority Member Bradish did state it correctly. We are proposing tonight that the authority accept the proposed stipulation to the facts. The facts would be that on September 27th, and actually that is a mistake, the incident started on September 27th, but the bulk of the violations were actually September 28th at 12:26 a.m. So I'd ask that that be corrected for the record. Between the hours of 12:26 a.m. and 1:52 p.m., the licensee permitted the loitering of intoxicated persons on the licensed premise, which is a violation of Littleton Code 3-2-11A2, conduct in establishments, and Regulation 47-900. This agreement is just to the facts of the case. There were no other stipulations or agreements as it pertained to any sort of penalty that the authority would impose. I'd ask the authority to accept the stipulation to the facts, and I'd ask that we proceed to the penalty arguments.
Does the licensee agree to the change in date?
That's fine. My recollection when reading the reports, I did think it was after midnight on the 27th, but I have no objection to that.
Okay.
No, I'm sorry, that it actually occurred on the 27th.
On the 27th? Okay. So I'll move that we enter Exhibits A through K, K being the stipulation agreement in order with the change to paragraph 1A from the date of September 27th through the date of September 28th.
I second.
All in favor? Aye.
Aye.
Opposed? Motion carried. Did you have some comments you'd like to
We
make
do, and I
at this
didn't know if
time?
we were, and I do, there was a comment earlier about if the stipulate, because this was, we went past the preliminary hearing, and if there was a mistake made. I wanted to apologize. My understanding is if we did a stipulation at the preliminary hearing that the penalty was then set and there would be no chance to present mitigation. That's why we didn't enter a stipulation at the preliminary hearing, and if that was an incorrect assumption, I apologize for that. But we do believe this is an appropriate stipulation given the facts of that night. Really the key to these violations, you look at conduct of the establishment, what are they permitting? And I think that night there's different evidence about different things, but we had a bad night. I mean, a real bad night. Things were out of control, and really the loitering, allowing the loitering of intoxicated patrons was what was really permitted. And I think that's real important because these aren't strict liability offenses. It's what was permitted, what happened. And I think allowing intoxicated patrons to loiter on the premises would be the most appropriate, and that's how we reached this stipulation. I remember the first time we were in here, you guys had all read the police reports, and there was an understanding of it was a real bad night, and what you really wanted to see, and what we'd like to present here in mitigation tonight, is what has the tavern done? What did they learn from that night? And I think there's a couple things in particular. They're not, and you look at all the policies and procedures and training. I think they tweaked a couple small things that have worked, and it's a corrective action, the kind of thing listed as the mitigating factors that we'd like to consider, and a little bit about the tavern and what they do for prevention and training. So with that said, my first witness would be Tommy Scarborough. I'm sorry.
Sorry, just procedurally, do you mind if we accept the stipulation and then move to?
Oh, absolutely, yeah.
Okay. I'm going to make a motion then that we accept the stipulation, which in this case is Exhibit K.
A second.
Any discussion?
I would like a little discussion. This goes as to conduct, specifically what conduct on behalf of the Littleton Tavern are we speaking of? Loitering? Where did they allow them to loiter? Every police report I read, the security staff is hustling somebody out the door. They're not allowing them to loiter. Loitering where within the premises? I just don't know what it goes to specifically on that conduct.
When we get to sentencing.
I'm sorry, again?
I think we'll get into that when we get to the sentencing arguments. I have a lot of information to present to you.
When was their last violation?
They don't have any. They keep coming before us more than, I think, any other liquor establishment in the city of Littleton.
Oh, wait a minute. I'm asking the
But
city attorney. When was
they
the
don't
last
have
violation?
violations.
There has not been an actual violation that has been filed. What you've seen them in front of you before was for the renewal process.
All right, we have a motion on the floor. Is there any further discussion?
Was it second?
It's been seconded.
Seconded.
We do have a second from you.
I did.
Hold the authority, please.
Authority Member Bradish?
Yes.
Authority Member Gunya?
No.
Authority Member Odell?
No.
Authority Member Cole?
Yes.
Authority Member Mather?
Yes.
Motion is carried. Next step is penalty.
We would call Tommy Scarborough. Witness.
Well, doesn't the prosecuting attorney get to speak first? Or no?
Normally?
No?
I'm ready and willing.
That'd be fine.
Okay, I'm
Okay.
just trying to stick to procedures here. I mean, I don't want you to confess to something that's not on the table, so.
Thank you so much.
All right, on behalf of the city, I'm asking the board to start at a minimum of 5 days with 3 held in abeyance, 2 days fine in lieu of. And I'm asking you, based upon what I'm going to argue to you now, that we get closer to 10 days, 5 held in abeyance, 5 days fine in lieu of. City's willing to go with a fine in lieu of, but based upon everything that's in the police report and based upon my prep and discussion with the 25 witnesses that were subpoenaed to come here tonight, there is a lot that you do not know that's going on. First of all, this happened on a Thursday night. It's ladies' night. In the city's position, this is one of the biggest problems, is we have a ladies' night going on. I spoke to numerous witnesses. There are a lot of people. It is out of control. The crowd is a little bit on the rough side, and nobody knows what's going on. You have bouncers that don't know what's going on. You have bartenders that do not know what's going on. Some of the witnesses that I spoke with, and we'll start with Police Report 2012005304. That particular case was a fight that occurred. The fight started upstairs. There were multiple parties that were involved. The one individual that seemed to be causing the most problems, security at some point did escort him out of the building. There were lots of yelling. There was glass that was being thrown. Some of the glass may have hit some of the individuals involved. Two of the individuals that were involved, Benjamin Sakis and Kevin Fawcett. Benjamin blew a .154. Kevin Fawcett blew a .135. They indicated they had at least 5 to 6 beers each. And they were some of the people that were involved in fighting with Sean Neal. That particular case, in the city's belief, is one of the more, not minor, but kind of is minor compared to what occurred in the other cases. The next case the city would like to discuss is 2012005305. This case is particularly concerning due to statements that I received from the parties that were involved. This was a fight that occurred between Chad Nelson and Andrew Halmo. Chad Nelson indicated to me that the fight would have been prevented if they weren't served so much alcohol. That's very telling coming from an individual that was intoxicated on that evening. I do not believe he took a PBT test. Chelsea Ryan, who was the designated driver that night for some of the individuals, she indicated that they were overserved. They should have been cut off. Andrew Halmo, I had a very long conversation with him on the phone. He was one of the other individuals that was involved in the fight. He basically said that the fight occurred upstairs. The bouncers did grab them. They began to separate them. They were told to get out. You guys have to go. Everybody in your party has to leave. You've been 86, those type of comments. He indicated, Mr. Halmo, that he was told by the bouncers that you need to take it outside. That boils down to one of the city's biggest concerns with the tavern is taking it outside is not solving the problem. Taking it outside is just putting the problem in the city streets for someone else to deal with it. What Mr. Halmo then told me, and this is another concern, is the bouncers are hands-on, they're pulling these people apart, and another fight breaks out across the bar. They leave these two individuals, and they walk away. They go to another location where another fight is occurring, and these two gentlemen are left there. Andrew told me that Mr. Nelson did appear, for whatever reason, to wander down the stairs, and he thinks he went outside. Andrew, he said he expected to be hauled out of there and thrown out. Andrew, what happened is he wandered downstairs to go buy another drink at the downstairs bar. He was standing in line waiting to get another drink when his friends, who had been upstairs collecting their belongings, came and found him and pulled him out of the bar. When they get outside, Andrew indicates they're right outside the bar doors. The fight continues. And they were told by the bouncers who were standing at the door that they needed to go to the opposite side of the street. that the fight couldn't happen right there. That's a problem. So not only do we have a potential over-service problem, we have no one calling the police, and we're telling the people that are in the bar that they have just served liquor to go to the opposite side of the street to fight. Don't do it on tavern property. Don't do it right out tavern doors. This is a problem that I don't believe has been addressed in the multiple occurrences that have occurred at the tavern. Moving to the last matter, 2012-05307. Oh, and one last word on the last one. When I talked to Andrew about whether he was overserved, I asked him if he was overserved. He said immediately, absolutely overserved. He said, oh, yes. He indicated he was coherent enough, probably not to be slurring, but he should have been cut off. He indicated, and this is a quote, they not paying attention to anybody, they just running around serving people, they were just too busy. Now in 2012-005307, this was another fight that occurred. I spoke with Travis Fitzgibbons. He blew a .163. Travis indicated that he was intoxicated. He went up to the bar. No one in particular was serving him. They just kept serving him. He indicated that nothing physical occurred inside the bar between him and the other individual, and I'm not sure his name. But the fight started right outside the door on the sidewalk, right outside the tavern door. And the bouncers were watching them fight at this point. This is the case where the bouncers were standing in the door, and this is the case where Officer Carlson came in the back door, noticed that the fight was occurring, and then had to call in and request additional help at the tavern. According to Travis Fitzgibbons, he was told by, and what he described as a big dude, a dude that was 5'8", he was in a blue uniform type shirt. He said he thought he was a bouncer, but couldn't tell me 100% that he was a bouncer. And this particular gentleman that was standing in the door of the tavern told him, you shouldn't be doing this, the cops are coming. The city's concerned about that once again. Why is there not an affirmative duty that the tavern is taking to call the police to make sure that these people aren't fighting? I can understand they maybe don't want it to happen inside, but when it's happening inside, when it's happening outside, they need to make sure that they put an end to it so that they can preserve the peace. He indicated that for approximately 15 minutes, they were fighting in the street. And this individual that he described standing in the door of the tavern was standing there watching them. No bouncer ever intervened, and they left right before the cops arrived on scene, and this is the case where they were found down the street. So we have clearly an over-service issue, we have clearly a failure to report, and we clearly have an inability to deal with the people that are coming in to your establishment, that are getting intoxicated, that are starting fights. The fights need to be stopped inside, they need to be stopped outside, the police need to be called, and it's not happening. I pulled the call logs from the night of the incident. I listened to approximately 2 hours of the police radio and the dispatch, and there was not one call made by the tavern. The only activity that was reported was from our officers as they were patrolling the area, our officers that were walking into the bar for a bar check. That was the only time that any of this activity was reported. So the city thinks that while the guidelines, if you're looking at it in a very strict sense and you're looking at conduct of the premises, 5.3 would be technically a first offense type recommendation. The aggravation is far beyond what would be considered a first offense, and I would ask that you get a little bit closer to 10.5. There's lots of aggravation in this case. And while you're to consider what went on this night, I think you can also consider the fact that this isn't something that has occurred inside a box. The tavern has appeared in front of you for no prior violations that have been filed, but for concerns that the city has had with repetitive overservice, repetitive fight-type situations that occurs within their establishment. That's all I have to say.
I'm not exactly sure how to respond. We had a stipulation, and I know there was some, the city attorney did interview some people, but I think there's been you've heard an interpretation of hearsay, and it might have, they think it was a bouncer. She's gotten evidence from people, and we're presenting it as fact, and I thought we had a stipulation based on the police reports. So we're being presented stuff here. Really, we've had phone conversations, but we did a stipulation. We called off any witnesses. I mean, we strongly dispute some of these things. The one about the bouncers, they had just locked the doors. The fight broke out. The cops came in the back door, and they said there's a fight out there, and we get an interpretation that that they were somehow watching, and then somebody might have been in an official thing. They think they were a bouncer and said take it across the street. We strongly do not believe that staff at the tavern told people to take fights across the street. We do stipulate there was a night when things got out of control, and I think evidence of that was with the people they were trying to separate. According to their policy, they would have called. They had to settle the situation first, and another fight broke out, and they lost control of that. I think there was a direct misinterpretation that Mr. Nelson said that there wouldn't have been a fight had they not been overserved. And the quote from the police report is the fight would have not been prevented. The fight still would not have been prevented if we were not served alcohol. These two guys were going to fight. What he was saying is whether they were served alcohol or not. The staff at the tavern, after they separated them, they would have called police according to policy. But we asked you, as part of the stipulation, we agreed that on that night there was loitering of intoxicated people, and we think we have guidelines under conduct of the establishment. But I think a lot of this is painted from these people after the fact, and I don't think it's an accurate. We would strongly dispute some of those facts that it just exactly did not happen. And as far as prior violations, there haven't been prior violations, and we have been here on 2 renewals, and those 2 renewals were based on police calls, and that's part of the thing we've worked with the city of Littleton. It's our obligation to call, and the training, the policies, the procedures, working with the police department. We were here on renewal hearings, and to editorialize, this is the proper venue. This is a show cause hearing, and I had a real problem setting renewal hearings after licenses expired based on police calls themselves without violations, because we're supposed to call the police. And so the tavern, I think, there's calls because they're trained, that's what they do. And I think a lot of this, what the city attorney's interpretation of that, I just don't think is fair under the stipulation and our ability to bring in people directly to combat that or to address it. But we're still would like to address some changes that were made since that night. There haven't been a problem like this since then. I think they're working, and I think that's one of the primary mitigation factors is what have they done, what do they do, what have they done so this doesn't happen. And it is the first violation, and the prior ones were based upon police calls, which is what they're supposed to do. But I would ask Tommy Scarborough now to answer some of this. Tommy, can you tell your name and occupation to the board?
I'm Tommy Scarborough. I'm the general manager of the Tavern Littleton.
And on either September 27th or 28th, were you the manager on duty?
I was not the manager on duty.
Are you the general manager there?
I am.
Okay. And have you recently filed to become the registered manager of the tavern?
Yes, I have.
Okay. And that's not quite completed? You haven't been fingerprinted yet?
No, I haven't been fingerprinted yet.
This was obviously a bad night for the tavern. Did you guys take a look at your policies and procedures? What did you change? What corrective action did you take?
Well, we did make drastic changes. We kind of tightened things up as far as what we should be doing. We became more diligent at the entrances. We found that we feel like in some of the cases that have happened, we haven't served people a whole lot, but then, we've come to find out that they have been intoxicated. So we've been more diligent about denying people entrance at the door, having more conversations with people as they come in, things like that, to try and help ourselves out in that way so that some of those people who might become problems wouldn't have that opportunity.
So that was a conscious effort to tighten the door security?
Yeah.
Do you think it's paid dividends?
Yeah, definitely. We haven't had any sort of incidents since that night.
Describe what kind of training, what kind of procedures you guys have at Tavern Hospitality.
Every front of house employee and manager is tip certified, as well as they have all attended responsible alcohol vendor training classes as a requirement of employment, and that's not only servers of alcohol, but hosts, food runners, door staff, everybody.
What's the tavern's policy about police calls and notifying the police?
Well, we notify police anytime somebody shows signs of violence, anytime there's any sort of altercation that could lead to something. Our policy is that we call the police, or anytime there is a safety issue with any of our guests.
Could I interject a question here? You talk about the training of the servers and managers and everything. What are your bouncers instructed to do? The city made a comment that the bouncer said to take it outside. In my belief, that's all a bouncer can do. But what are your bouncers' instructions in the case of a fight?
Well, in the case of a fight, we would obviously intervene, prevent that from happening, and then in most cases, there's usually an aggressor. We usually try and get that aggressor out right away, and then obviously both parties would be asked to leave in that sort of a circumstance, but we would do it separately where we're not pushing them out both the same door, and then anytime there's signs of aggression and things like that, then we would call the police immediately
Actually, you would have probably called the police before that. As soon as there was an altercation, the first thing you do is call the police, probably simultaneous to the bouncers trying to break up the fight. Am I getting ahead of myself, or is that really the case?
That is the case, yes.
So by the time they hit the street, the police have been called?
Yes, sir.
And is that a written policy somewhere?
That is a written policy, yes, sir.
Okay. Proceed, please.
Have you seen the written policy with the Tavern Littleton?
Yes.
Is that a copy of it?
That is, yes.
And are the, Matt, pass that.
Thank you, sir.
I'll make a motion that we enter this as Exhibit L. It's labeled Tavern Littleton Police Department Policy.
Second that.
All in favor?
Aye.
Yes.
Are your bouncers, is that part of your training with your bouncers?
Yes, sir.
Okay. Have you had any turnover with your security staff since September 27th?
Almost complete turnover. I have one one door personnel who's the same as that evening.
How many security people do you have on busy nights?
7.
And of those 7 that were on that night, there's 1 left?
That's correct.
It wasn't a direct result of this, but just...
Yeah, sort of, philosophical things. Some of this may be indirectly coming from this night. We just wanted to make sure that our door guys were following the hospitality mentality as much as possible and not maybe, encouraging these types of things, or maybe, maybe not encouraging might not be the right word, but maybe just, I don't know, not minding when things like this happen, I guess, would be.
On the night in question, how many bouncers did you have on duty at the time?
7.
7? And you still have 7 now?
Yes, sir.
Okay.
But of that night, 6 are no longer with you?
That's correct.
So that night, you probably could have used more than 7.
To be quite
So
honest
that was
with
an
you,
exceptional night, and that's why I made that observation. You can't double your security people just because you think it might not be a good night.
well, there's that, and I mean, to my knowledge and my information, there was 2 incidents that happened inside the building, and police were present for the initial incident. So, I mean, I don't know in this case that more door guys would have prevented what happened later in the evening.
You just provided us policies. What was the purpose of providing us this?
Oh, did they have a written policy? This was something worked out with the Littleton Police Department?
How do they
Train their people?
How do they enforce it?
Well, this is a policy that's in place, and there would be reprimands if this policy is not followed.
How do people know about your policy?
When we inform them of it?
Do they have to
Through
sign
their
it or
training?
anything?
No, they don't have to sign it.
It's not a condition of employment?
It's not, no.
And if they violate it?
If they violate it, there would be a reprimand depending on what the situation might be, or a possible termination. I mean, just like any other policy that we have.
I would propose you also add an item at the bottom that says, if in doubt, call the police.
Was this policy developed subsequent to the September 27th?
This policy was developed last fall, I believe, somewhere around that time frame.
President Taberner.
Just a question. I was curious.
Okay.
Fights that your staff was aware of, were the police already there?
That's the information that I've been given, that there were police present when it happened, yes.
Okay. I'd have nothing further, but if the board has any more questions of Tommy.
How long have you been there?
Since we opened in May of 11.
Okay. When it went through renewal, there were certain stipulations that the tavern agreed to. Are you aware of those?
Yes, sir.
And do you think that you have followed those?
I believe that we have, yes.
Have you posted no loitering signs?
Yes, we have.
Where are they posted?
They're posted on the rear entrance and the front entrance, front door.
Do you believe that you have adequate security personnel
I believe so, yes.
to ensure safety and lawfulness in the establishment? And you said one of the new things you started doing was monitoring the entrance?
Well, not a new thing that we were doing, but something that we felt was a strong point of emphasis that we needed to emphasize further moving forward.
And
We have progressively increased that area, and we've added scanners and things like that over time, and I just felt like that was an area where we could be stronger. So it was more of a point of emphasis as opposed to something new.
And part of the agreement renewal stipulation was to monitor and control all entrance and exits.
Yes, sir.
You feel like you've done that?
Yes, sir.
And what do you believe led to this getting totally out of control?
I really don't know, to be quite honest with you. I mean, like I said, the two incidents that happened in the establishment, when police were present, I believe were handled fairly well, and then, you know, the rest of the police reports are kind of things that my manager or my staff couldn't have controlled.
And how do I know a bouncer if I'm in there? How do I know that somebody's a bouncer?
They wear a tavern shirt.
Okay.
It doesn't say security or anything
It
like that?
doesn't say security, no, sir.
So how can I get a tavern shirt? My point being is, if somebody comes up to me and tries to break up a fight, how do I know it isn't somebody else just jumping in on the fight as opposed to being a security trying to break it up?
I guess I don't know. They wear uniforms, just like the rest of our employees, just like how you would know your server or your bartender or your busboy. They wear tavern uniforms.
So your employees wear a uniform?
Yes, sir.
Do all bouncers get training?
Training as far as?
Well, if
They are all
you and I
tips.
tell you
They
I
are
wanna
all
be a-
tips certified, and they all go through the responsible vendor training, which teaches them signs of intoxication, things like that. Yes, sir.
all bouncers do?
Yes, sir. Every front of house employee at our establishment.
And how do you account for no police calls being made that night?
Well, the incidents that I believe we could have possibly been aware of, there was already police presence in the building, is my understanding.
According to the reports, they were there on a bar check.
And
Understand, they
the
came
other
in the door, but-
incidents from later in the evening, we wouldn't have had knowledge of to be able to call the police because they didn't happen at the tavern.
And do you believe if you break up a fight and tell them to take it outside, that you have done what you need to do?
No, absolutely not. You call the police. And that is our policy.
When do you call the police?
Well, I mean, obviously, a situation needs to be under control, and then your first step after that would be to call the police.
You've been there from the beginning.
Yes, sir.
The first time that the licensee appeared before this authority, they said, we're out of control. We didn't expect, and they gave a list, we didn't expect as many people. We didn't expect that they would not be Littleton residents. They'd be coming from out of town. But we realize we're not in control. We're going to do things to get under control. And they're back again, not on a violation, but with incidents. And once again, they're not under control. This incident, already stated, the establishment was not under control. But you maintain it's now under control?
Well, I wouldn't say that the establishment was under control. Some of the patrons were under control or out of control, is the way I would put it.
Okay, can I phrase it this way? The situation within the establishment was out of control
For a brief period of time, I believe it was, yes.
until it went out on the street.
Well, until the situations that we were aware of were handled.
Thank you.
How did you become aware of it?
My manager called me, and that's how I initially became aware of it. I wasn't on the premises that night.
And what was your reaction when he called you?
Well, clearly I wasn't very happy about it. I mean, this is not what we do, you know. I mean, I can say that, you know, before this particular night, there was a very long stretch of time where nothing happened, you know, nothing adverse happened. And since this night, nothing adverse has happened in our establishment. And I think, you know, maybe the picture that's being painted based on some of these few incidents is a little bit unfair as to what we do on a regular basis.
Thank you.
So this was Thursday night, which is ladies' night, and that's every Thursday night?
Yes.
Is this typical for a ladies' night, what happened on this particular night?
No, absolutely not.
No, there's usually not fights or people being served a little too much or fighting in the street?
I would say definitely not. This is definitely not typical.
Okay, I have a question for you. What's the occupancy that, according to the fire department, of your establishment?
I don't know it off the top of my head. I don't know it.
And how do you keep track of it?
Clickers.
It's a two-part question. Clickers. So what's the most amount of people you'll let in there at one time?
I really don't know off the top of my head, sir.
Okay. I have another question here too. The fight that was going on in the street where the police came in the back door and couldn't get out the front door because they were locked. Were there employees on hand that had the ability to unlock that door?
I couldn't say specifically if there was a man. I mean,
Why weren't there
it's
somebody
only-
monitoring the door? If that door was locked,
It's only a keyed lock, so you can't, any.
I
employee
understand
can't just
that.
flip it open.
I understand that. But if it was locked, were there still patrons inside at that point in time?
No,
No, for sure.
absolutely. We don't lock the doors until the last guests leave.
Okay.
What are the hours of operation for ladies' night?
For a Thursday or for, on Thursdays, we're open from 11 a.m. until 2 a.m.
What about other nights?
It varies. We open at 11 on Monday through Friday, at 10 a.m. on Saturday and Sunday. Based on business, we close anywhere from midnight to 2 o'clock on Sunday through Wednesday and open till 2 on Thursday through Saturday.
Now, when you did the renewal, when you agreed to adjust your hours for ladies' night, was that adjusting them so they were longer?
We adjusted the special. We adjusted the ladies' night itself, which used to end at closing time, and we adjusted it to end at midnight.
What is that special?
The special for ladies' night?
Yeah.
is
What's the offer that's being offered until midnight?
the offer is ladies drink free from 9 till midnight.
How does one bouncer know what the other bouncers is doing? How do they communicate between each other?
We station them in a way that they can see each other, and they communicate through flashlights. They flash each other when they need assistance or need to talk to each other.
One of the allegations was there was a person upstairs drinking, and the bouncer basically cut them off, if you will, but they just went downstairs and got a drink.
Well, I mean, I can't attest to that. I can say that our policy is if somebody's cut off, then that decision is communicated to all the bartenders on staff, and typically that guest is asked to leave.
And how is that communicated to the bartenders downstairs?
The door personnel would do that, or a manager, or the door would tell the manager. Typically, a manager is the person who cuts people off. The door staff informs the managers if they see something that they feel is amiss. Then the manager makes an assessment. The manager typically will cut that person off and then communicate that decision with the staff.
Okay, well, according to the statements that the prosecuting attorney had, that Nelson and Helmo were separated and told to leave, and Nelson left, but Helmo went downstairs and had another beer. That's according to Mr. Helmo, which I'm sure has his own agenda.
Well,
But,
I would like to say that she said that he stood there in order to get a beer but never was served one.
okay, he
That
was.
is correct. That's what I said.
Oh, I'm sorry.
He went downstairs and stood in line to get another drink, and then his friends had, after they collected their belongings, they came and collected him and went out the door.
Okay, so he wasn't not served by your bartender. He was escorted out by his friends.
Correct.
Was she going to serve him, or you don't know, or
I would think not.
you would hope not? Okay.
Are you the person that the buck stops with?
Not in the company, but at my store, yes.
And do you accept responsibility for this?
Yeah?
You've been with this tavern since it opened. Have you been with the company longer than that?
I've been with the company for 5.5 years.
What other restaurants have you worked at?
I previously worked at the Lowry location.
And how many are there in the tavern system?
There are 6 taverns, plus the Cowboy Lounge, plus the Soiled Dove. So there's, and now Mile High Stadium. So there are 8 total, or 9 total.
And this company's been operating for how many years?
Since 1997.
Okay. Do they have ladies' night at the other establishments?
They do.
So they're pretty familiar with what can happen. On ladies' night, they're familiar with the whole bar scene. They're familiar with everything that we've been talking about tonight. They've been dealing with these kind of issues for many years.
Well, I wouldn't necessarily say that, but they are aware of issues that can potentially arise.
You know, the city attorney said something that, you know, the bouncers and bartenders did not know what was going on. In what sense?
You would have to ask the
what does
person who
that
said
mean?
that.
As evident in the police report and my conversations with all my witnesses, the witnesses indicated that there was really no continuity. The bartenders were just serving whoever was coming up. There were no bartenders that were paying attention to who was being served. They were just, as many of them said, slinging drinks as fast as they could. Same with the bouncers. Many of the witnesses reported, and keep in mind, these are all witnesses that got in trouble. I mean, the majority of them are witnesses that I saw in criminal court that pled guilty for their actions. And these witnesses were saying, you know, the bouncers weren't necessarily paying attention to what was going on. Andrew Halmo and Chad Nelson were two of them that the bouncers left them. They were upstairs having a fight, and the bouncers walked away to handle another fight.
I have a question of the prosecuting attorney because I do not have a copy with me in regards to ladies' night. Was that at one point part of a stipulation agreement, something in regards to ladies' nights? And if so, were they in compliance that evening?
This is really testing my memory. I do not believe that we had any agreement regarding ladies' night in our original stipulation.
If I may, the licensee agrees to continue to limit the hours and operations for Lady Night Special and Friday and Saturday's night specials.
Then that's probably what we agreed
That was in the
upon.
renewal stipulation.
I'll remind the authority, though, that this happened 10 days, about a week or two after you had lifted any of the requirements from that stipulation as a condition of their renewal. So they were no longer under that requirement.
But regardless, we still do follow.
They were no longer under the renewal stipulation requirements?
Correct.
No, I remember the motion, I believe that I made, but the motion that was made was to renew their license. So going forward, they weren't under the stipulations that they had been.
They weren't under the renewal stipulation when they renewed their license.
That's correct.
Right.
They had been at one point when they came back in front of us. We renewed their license, and then they weren't.
We actually volunteered to keep them going, and the board elected to.
Yeah, I mean, I remember the discussion of the board was over the appropriateness of that stipulation, and so the motion itself became a renewal.
It was
But
not
I
directed,
think,
but
it's been
not directed.
established that they did change the hours of ladies' night.
And we
It's their-
continue to follow that.
Whether that
the
was
same way.
required or not, you're in compliance with that.
From reading these reports, it sounds like some of the people drink and then come into the tavern. And now you're saying that you're watching the people that come in at the door a little more closely for that?
Felt like that was an area of opportunity for us in avoiding some of these situations, yeah, absolutely.
As a result of that, have you seen a noticeable difference in people you've turned away?
Yes, absolutely.
Numbers at all, or?
Not specific numbers, but I mean, I can tell you that we get called to the doors a lot more than we used to make judgments and to back up employees when they have denied entrance to people.
Just out of curiosity, what is that? I mean, if I were to come to the front door, is it just in the course of asking for my ID and me producing it, or I mean, I'm just curious how you guys do that.
Just conversations. There's several different ways you can do it. You can ask them questions about their ID to get them to think, about something else. You can just ask them how their night is, what they've been doing, things like that, and you can get a gauge based on their speech and what are just normal, visible signs of intoxication that we have to follow.
Your procedures are pretty much the same as all the other taverns, I take it?
Yes, sir.
And is the history of the other stores, to the best of your knowledge, similar to yours in that you hardly ever have an incident, but you had a big one night? Do the others have more incidents?
I can't really answer that question,
the
to be
same?
quite honest with you, yeah.
Just as a point, I represent the Tavern Hospitality Group, and the president, Bill, is here. This is the second service violation in the history of the company. And we're talking with 9 different venues, tens of millions of dollars in alcohol sales, and this is the second time ever that there's been a service violation. There was one selling underage at Lowry a couple years ago in Denver, and that is their entire record with really massive amounts of volume compared to other establishments.
I think we can all agree that this got totally out of control. And one of our main concerns is how are we going to prevent it in the future? And what I've heard is we're going to be more careful at the entry, and we're going to do some more training, which doesn't really gives me a warm and fuzzy.
Well, we can address, we have some more witnesses. And what.
Please, sir.
Good evening.
Evening.
David, can you tell us your name, occupation, and a little bit about your background?
My name is David Wrights. My background is primarily in alcohol beverage law enforcement and regulation. I was a street police officer in Greeley, Colorado in the mid to late 70s. In 1979, I went to work for the Colorado Liquor Enforcement Division. I was employed there for 24 years as a field investigator, the chief of enforcement in the last 12 years as a division director. Retired in 2003, and since that time I've done consulting work in alcohol beverage law, training to both licensees and also law enforcement alcohol beverage law, and some legislative work at the legislature on alcohol beverage law related issues.
David, were you hired as a consultant by the Tavern Hospitality Group?
Yes, I was.
And you also, in addition to being a consultant, do you do ongoing training with them?
I do training for their staff. All of their staff go through TIPS training. I've got another program that's been approved by the state of Colorado. Colorado approves approximately 19 different training programs around the state of Colorado. Mine's one of the 19 programs that the state has approved as meeting its responsible vendor serving requirements, or responsible vendor requirements. TIPS is one of those programs. My program is one of them. The Tavern Group hired me starting last summer to train all of their employees to go through a second. So they all go through TIPS training, and they all go through my training. My training's a little bit different. It has a little bit more of an emphasis on legal liability than TIPS. TIPS is very good on serving techniques. Mine covers a little bit more about the law.
As part of your consulting work, were you able to review the situation at the tavern, the policies and procedures, and make any recommendations?
Yes, sir, I was.
Can you describe that for the board?
Specifically to the Tavern Littleton, my biggest concern was I do think that looking at the outline of the premises, where you've got the 2 entrances where they've got a doorman at each, and they've also got a total of 7 people on those type of nights, that should be enough security staff to try and control it, except maybe in some extraordinary situations. I guess those things can occur. But I think the biggest thing is communication between the security staff. Obviously, controlling the front door, not letting a drunk in is an important issue, because you let a drunk in, you let a problem in the door. And I think they understand that side of it. But also those rovers. They've got 5 people that rove. And the rovers just can't be watching for people that are going to get involved in a fight. They really need to act as intervening people, to start seeing if people are acting intoxicated before they're served a drink. They see someone who's acting intoxicated, they need to identify them before they become a problem, get them to the front door, get them outside, or get management involved in dealing with them and identifying them. I think that's probably one of the key issues where I've been involved in doing consulting work in nightclubs and places like that. I think that's one of the key things, that roving security guard really has to have an eye on the behavior of the patrons, and not just whether they're involved in a fight, but really the level of intoxication, because once that intoxication level gets up, and people, they may not show visible signs when they're served, but one drink later they could be at that level. That's when they need to be identified and taken care of.
Is the increased awareness for the rovers something that's going to be implemented by the tavern?
That's what I've been told. I've been told that they will implement that. That was, I think, probably the most significant issue that I saw as being an issue there.
And you also noticed the door issue, but by the time you looked at it, they had addressed that.
They had already told me that they were focusing on the entries, about dealing with the intoxicated patrons at the entrances.
Anything else that you'd like to discuss with the board this night, or Littleton, or the tavern in general?
I would say that what my impression of dealing with the management of the tavern is they take this all very seriously. I mean, for all the businesses that they've had, and then to go to the extra expense of hiring me to do specific training before they've even been an incident. I mean, we trained all of the people, and probably when this incident occurred, they were probably going through a portion of it, but we trained over 450 staff in a period of about a month and a half. And so that's pretty intensive. And so we brought all the people together to go through the training, and the management required everyone to attend the training. And that included all staff, not just bartenders or other people. They required everyone to attend. So my impression is, and working with them, is that they take this very seriously. It's an issue of concern to them, and I know that they want to have a good relationship in the communities where they're at. And also, I mean, they don't want a bad reputation either with yourselves or with the law enforcement agencies that they deal with.
Any questions from the board?
In your training, do you come to the tavern in Littleton? Have you been to the tavern in Littleton and actually worked with the people one-on-one there?
This is the first time I've been to the tavern. Littleton was after this incident occurred, and it's been recently going in and looking at the logistics of the premises and talking with the management. The training classes that I did were all done over at the Lowry location, because they've got the soil dove downstairs in audio. It's kind of a large auditorium where I could do the training at. So that's where the training actually took place.
And you visited the tavern today, is that true?
Yes, I did.
And do you have any recommendations from your visit today, or are they still pending, or?
No, my visit was previous to today. I've been there today too, but my recommendation to them was I think they really need to work with in talking with the management, and I think then that rovering situation really is the kind of the key focus. That's from looking at the situation and hearing the police reports and hearing about there were problems in different locations. I really think that it seemed to me like they weren't doing as good enough job as far as identifying people that might become intoxicated on the premises. I didn't see any evidence from what I saw of necessarily serving a visibly intoxicated person, but I did see evidence of not focusing and finding people once they became intoxicated and making sure that they were cut off or identified.
I appreciate and respect your knowledge and what you've accomplished. Good on you. One question only. Would it be beneficial for you to visit it on a ladies' night?
I think so, absolutely. I think that it would make sense to go on a ladies' night and see where it's at and see what the issues are. I do know they've got a good-sized crowd in there just in the afternoons and evenings just for dinner, so it seems like the place has a pretty good-sized crowd just with that. But you're right, it would be a good idea to go in and take a look and visit that and actually see the operations and see how they're working.
Yeah, I have no more questions right now.
Okay, thank you.
Thank you, sir.
Thank you.
Yeah.
Thank you.
Bill Schallmoser? Hi, Bill.
Hello there.
Can you tell us your name and occupation, your experience?
Yes, I'm Bill Schallmoser. I'm the president of the Tavern Hospitality Group.
And what's your experience with the Tavern Hospitality Group? What's your bar experience?
I've been in the restaurant business since I was 14, and I just turned 54, so I'll be hitting 40 years this summer. Over 30 years in management, ever since college. Been with the Tavern Group for 7.5 years.
Are you part of the group that sets policies and procedures of the Tavern Group?
Absolutely. I'd always be included in those discussions, okay, for sure.
And when you were part of the opening of Tavern Littleton?
Yes.
And there were some initial problems at Tavern Littleton. Do you think it's been an ongoing process to address those?
Yeah, I mean, we've made significant changes since the day that we opened, from the initial dress codes and changing of the music format, trying to help control the crowd, the limiting of the specials on ladies' night, the use of ID scanners. We've talked to the police department and altered our police call policy that you were presented earlier. We modified that to be a little bit different than the standard tavern policy, where I think the last entry on that sheet, it says we call as soon as someone if I have to go up to you and say, sir, I think you've had enough to drink tonight, and you show me any resistance, normally or typically in the past, I wouldn't immediately call the police. Usually you can have a conversation with someone, and if you've done it for a while, you can smooth things over and get them a ride. And when we met with the chief, she was wonderful, and she asked that if there was any resistance there, any refusal of leaving, to call the police. So we do. So we've altered that policy. We, in meeting with the police, we came up with a code of conduct that we posted on our doors at their request. So yes, to answer the question, is many changes have been made.
You've had a chance to discuss these issues with the police department?
Absolutely. We've met with the chief and her division chief and some of the commanders on 2 different occasions, and had very good and healthy conversations with them, and a great group of people, and they helped us form some of those policies.
Have you reviewed the police reports from September 27th, 28th?
Yes, I have.
And what's your take on that? What would you like the board to know?
Well, I'll start by saying I'm sorry that it happened. I mean, I apologize to the city and the police, and that if we were in any way, shape, or form, and responsible for depleting the resources of the police department, that's embarrassing. I take that to heart. I'm very fond of the police department. I want you to know that. My brother was a cop. My best friends are Denver police officers. I have the utmost respect for them. And to know that we put them in that kind of a position, or we contributed to it, it's embarrassing. It was a bad night. It got out of control. There were many great Thursdays leading up to that, and there's been many good ones since. It was a bad one, and we do apologize.
Are you part of the group that implements the procedures throughout the company? What's your training policies?
Training policies regarding alcohol service?
Yeah.
As David had said, every employee goes through tips. We even have our own in-house instructors, so we don't have to wait for the Anheuser-Busch's, the big companies, to provide those classes for us. We have one that teaches all of our employees, and then we brought David in to do that secondary piece.
Tavern Littleton, active in the community, charity work, that kind of thing?
I am, absolutely we are. I'm very proud of it. I don't think that there's anyone that has called from a Littleton school or a Littleton organization or charitable group that we've said no to. We've always provided them with whatever they ask for. Absolutely.
Is it your intent to reach out to the police department again and start the dialogue?
I'd love to. I enjoyed both times that we met with the chief, and like to see her again. And we would love to hire Littleton police officers to work for us off duty, as we do in Denver. It's our belief that it's a great deterrent, a wonderful deterrent in Denver. People see the police officer, and they see the uniform and the presence and the badge, and it keeps them from misbehaving. At least I believe that. But I understand that Littleton doesn't allow that right now. But if they ever do, I think we'll probably be the first one signing the forms to get that done. So,
anything else you'd like the board to know or consider?
No, I know that we had a bad night, and I know you're going to rule on this, and you're either going to suspend us or fine us. I understand that. We accept it, and as a company, I accept responsibility, and as the leader of that store, Tommy accepts responsibility. So I hope that it's not too severe, but I know that it's coming, so I'll leave it at that.
Sounds like you have a high level of confidence that you're not going to be back before us in the near future explaining a violation.
I sure don't ever want to be here again. Not that you're not nice people, but rather not see you in this building.
Your Lowry facility is larger. It can get quite loud. Why do you think it happened here and not there?
You know, the Lowry location is sort of it's an urban, it's a Denver location, but it's sort of suburban, and it sort of rolls up early at night out there. We don't do the ladies' night at Lowry, but we have it at downtown, which is a much bigger facility, and we don't have any problems there. We do it at Wash Park, which is a small location. Don't have any problems there. We do it out at Tech Center, which is Greenwood Village.
You have officers from Greenwood Village at your establishment there?
Unfortunately, they don't allow it either. The police officers asked me about a month ago, and they said, "Why don't you hire us?" And I said, "I can't. You got to talk to your chief or somebody." Believe me, we wish we could.
A thing that concerns me is we keep talking about a bad night. And I'm a patron of the tavern. I like the tavern. I want to see it succeed. I know that you don't want what's happened to continue to happen, but we're not talking about a bad night. We are talking about, since the opening, a bad history. And continually, there's a recognition that there's a problem, and that I believe there's a sincere effort on behalf of the establishment and yourself to get this corrected. I'm just very concerned that I don't know what else, I'm wondering what else can be done, because it's not being corrected. We still are having incidents of over-serving, of in particular violence. I'm not suggesting you do this, but we had an establishment, again, historically, on Main Street, that the owner was coming before us, and he didn't want to. He just finally said, "Okay, I'm just changing the format." Hasn't been back since. I'm not suggesting that you do that, but I'm saying that I've seen this. I've been a citizen of Littleton for 42 years. I've watched this. I just really want to see you succeed. I just am very concerned that with everything that has been done, we still have the same continuing pattern.
It concerns me, too. I was so pleased to see such a decrease in issues and such a decrease in police calls, because we didn't have to call. We weren't having the problems. And to see this spike on September 20, whatever it was, you know, it nauseated me. I'm very happy that we haven't had any issues since. Why did it happen that night? I can't tell you. I don't know if the stars were in a line or something was working against us, but it was a very, very terrible night. Proud of the days before it, and I'm very proud of the days after it, but I'm not proud of that one at all.
Appreciate you coming in, appreciate the action and concerns.
I guess I can say I'm glad to be here. I'm not really glad to be here, but I'm glad to
tavern.
be able to answer your questions.
We like the tavern in Littleton, but certain nights we don't.
Well, that night I didn't either, that's for sure.
My observation is we've heard a lot of good stuff tonight. You've said, in my opinion, all the right things that you need to say. I think we still have a concern, and I don't know what we can do to alleviate that concern. We're not really in a position to hammer you, and I don't think we'd be inclined to. We see the value of your business to this community, and by and large, it's been a good member of the community, and we want it to continue that way. But regardless of what we do tonight, I think we're all still going to have a concern that we may be talking to you again in the next year or so, and none of us want that to happen. So I just want to stress to you that whatever happens tonight, the next time is probably going to be considerably different, and our actions the next time will be considerably more than whatever happens tonight. And I would ask you, all of you, to keep that in mind.
Hopefully it won't be a next time.
Yes.
That's plenty.
Yes. And I understand your point completely.
Do you have additional information, Counselor?
We have one more witness, but I think he's here to say just exactly what the chairman just said. You've been waiting for so long, I would like to
We'll be happy to listen to him.
Thank you, everybody.
Thank you.
Mr. Davis?
I'm Reese Davis. My primary occupation is as a real estate investor, and I own the property from 2509 to 2579 West Main Street. And I previously owned the site of the old, what used to be called the Main Street Tavern site, that I subsequently sold to the tavern. And we took a lot of time and effort to assemble that whole block. And we let go of that site as a sale to the tavern with a lot of reluctance, because it's very hard to own a block to block. And our vision was to create a great downtown environment on our block. And we took a lot of time, and we went to a number of the different taverns, and we felt very good about what we saw at the tavern. I can tell you that in the negotiations of the sale of that and subsequent to that, we also have a parking lot agreement with the tavern folks. They've lived up to everything they have said that they would do. I can't speak to the violations. I wasn't there that night. I'm too old to go to ladies' night and stay up till 1 in the morning. I have been on there on a Thursday night, and I remember it because my daughter was in town, and it was a Thursday night in September, and it was lively. Did I ever feel threatened? Did I ever think anybody was out of control? The answer is no. But when you get over 50, you don't spend as much time out after 10 o'clock. So what I'd like to reiterate is that whenever we've had a parking lot issue, whenever we've had a trash issue, whenever we've had any kind of cleanup issue in the lot, most of the time I don't even have to make a call. Tommy and his crew are very good about keeping the lot clean and making sure it's inviting. If I ever do have a problem, I pick up the phone and call them, and it's taken care of. So I feel that they're a good neighbor. I think that they bring a good element to Main Street. These charges concern me as well, because what happens there reflects on the whole block, and it reflects on all of Littleton. So I share their same feeling that it's nothing that I want to see happen. But sitting back there for 2 hours, I did think about one thing. I've been a Bronco season ticket holder for 15 years, and I've never, ever been there when people weren't drinking beer and having a good time. I go to maybe half the games a year because I share them with somebody else. This year there was a fight in back of us. And was the guy overserved? Probably. But did he seem drunk? No. But it was probably that last beer, and all of a sudden a fight breaks out. And people got on it, and they threw him out. Now, did it escalate to 5 fights? No. But in my own mind, I kind of thought to myself, well, I never have seen this kind of activity at a Bronco game before. And all of a sudden, lo and behold, something breaks out in back of us. And it's a season ticket holder that I see it maybe every second or third game that I go to. I don't know if that's a fair analogy, but you have a lot of time to think about things when you sit and wait for your time to speak for a couple hours. So.
Do you go to the Oakland games?
No, I do not.
Oh, okay.
Yeah, I've seen fights at the Oakland games.
Yeah, it's one you avoid.
Well, I think your point's well taken, that it can happen anywhere. You do the best you can to avoid it, but even in a venue like the football stadium, it happens.
The nearest neighbor, has the tavern been a positive influence in the block, or has it been something good?
It's been very positive. I mean, when I talked to all the other tenants on my block about, what we were planning for that site, everybody was real excited about it. Boy, it'll bring us additional business. It'll help us with walk-in traffic. We can co-market. We can do things together, and that's exactly what's happened. I mean, everybody on the block feels better because of their presence there. We had one issue, and a sign was broken, and whether or not it was Merle's or Tavern, we don't know. One sign was broken, a blade sign in front of the building, and I called Tommy and his crew, and they said, go ahead, replace it. We don't know who did it, but it happened late at night. And I had my tenant replace it, and they reimbursed me for it. I mean, that's the only problem.
I appreciate your comment. I share your concern and information. However, our number one concern has to be safety of the community.
Absolutely, and safety for everybody along Main Street. And so I'm with you, and I appreciate that comment, and I believe it myself.
Any other questions?
I have no questions for this gentleman.
Thanks for waiting.
Thank you.
So I guess we're into the penalty phase, and we've heard a lot. I think the Tavern Hospitality Group is a really good, responsible company. The track record with, again, tens of millions of dollars in liquor sales, for this to be the second service violation they've ever had, we'd like the board to really consider that. It was a bad night. There's no denying that. We do want to point out a couple things. The two fights that the actual staff was aware of, the police were there. It wasn't. There was not fights that were ignored. We do not agree with statements that employees of the tavern told people to go across the street. We can test that. I don't think that's in the police reports you have. But the police were there on the two fights that they knew about, and the two guys that were going to fight, no matter what happened, that's the one that they really messed up. That's the one where they really lost control, in that they had separated. They did what happened, and it looked like a more serious fight broke out. And I think that fight was more serious. The police reports, this Mr. Neal had just gotten out of Department of Corrections. He was looking, and it exploded, and it really taxed him. That's with that night. I think a single charge of allowing loitering on the premises is appropriate. Loitering of intoxicated people, that is part of the conduct of an establishment. That is a violation. I don't think the tavern, night in, night out, is the kind of place, tavern, that creates this atmosphere that you normally think of conduct of an establishment. We got 365 days a year. I don't think 99% of the time things are fine there, and they tightened. They had a problem. They took some corrective action. They have, when they opened, they had 2 security people. They now have 7, and those little things about checking the door better, they appear to have paid off. David Reitz has been hired as a consultant. He's making another recommendation about the roving staff. They do as much or more training than any company in Denver. The track record's incredible. And so I think the standard, I don't see a reason to go beyond the standard guidelines of the 5 days, 3 in abeyance, and we would, as a first offense, we would request the fine. I do think it's a little unfair. Again, we got renewals. We didn't contest those things that happened before, but they were, again, we were set for renewal based on police contacts alone. I mean, someone made a determination to have a renewal hearing because there was a number of police reports, and that's their duty. So to hold the fact that there's been police reports when that's their duty, that's their responsibility, I don't really think is fair. I think this should be treated as it is, a first offense, a very bad night that is a violation. We admit it's a violation. We take responsibility. But I don't see anything more than that, especially with the track record of the company, that should go beyond the guidelines of the 5 days, 3 days in abeyance, and 2 fine and lieu on the 2 days. They do know there's going to be time in abeyance. We do not want to see this liquor board again. We know the ramifications of a violation the next year. While these, they're looking at a lengthy suspension that would drastically hurt the company. There wouldn't be a fine in lieu. So we're here. We've got a violation. It's a first, but I don't see a reason to go beyond the guidelines. That's all I'd have.
Thank you, sir.
Council, have any comments?
No.
I've got a few things to say.
You usually do.
Looking at the police reports and discounting the hearsay evidence from the phoned-in testimony. I got to go with what says in the police reports. According to the police reports, Nelson and Helmo, they were going to fight each other even if they weren't at church. This guy, Sean Neal, was described as a skinhead, if I'm not mistaken. And the other gentleman, I assume it was some sort of a racial incident that he was upset about. The other gentleman that was fighting outside something about being with the white boys. Sounds like another racial incident to me. Racial problems and discussions and fights have been going on since time immemorial. I don't really think that's the tavern's fault. The issue is that, yeah, it may not have gotten to the point of a fight if they had been monitored alcohol, their alcohol consumption had been monitored better. The one thing that concerns me is the statement from one of the officers that while they were addressing the two fights in the bar, there were two other fights that were breaking out in another part of the bar. And the officer did not have enough backup to go over and attend to that situation. That concerns me. And again, I realize this was like the perfect storm. And I don't know how you solve racial problems. I don't know how you solve two guys that have hated each other since 8th grade. But I think that possibly and hopefully the conditions that you're putting on your staff as far as monitoring the alcohol consumption and the training that they're going through, hopefully that'll solve it. But I think my personal opinion is that 5 days with 3 days held in abeyance would be good. But I would not suggest a fine. I would like to see a Thursday night closure.
Any other comments?
The problem that I have, the concern that I have, is this is a quasi-judicial body, and I am able to separate in my mind, since the stipulation says no over-service, not to consider that. But we had the head bouncer come up and say, yeah, we're over-serving. I can dismiss that when making my decision, but what I do know is that not by police reports, but by the licensee's own admission from the first time they came in for renewal, that they said the incidents that were being presented to us because they did not have a handle on the situation. That was what the licensee and counsel told us. Coming back again, it was the same thing. We're going to do more. We're going to get this. We don't quite have a handle on the situation. This was a case where, again, they simply did not have the handle on the situation. I am really pleased to see the hiring of the consultant and hope that with his help, a number of these things can be corrected. But I didn't hear in the testimony and questions asked from authority members how the situation with the bouncers was going to be addressed. Yes, they're in uniform, but the uniform is something that is really not distinguishable. Just about every tavern that I know sells a T-shirt with their name on it. The problem with the communication with bar staff about serving really has not been addressed. I want to see the licensee do well. I do have concerns because we started out, again, first time with incidents of waiter taking an unconscious patron out and placing them on a back bench. I don't know why the police didn't bring this to us only as an incident and not a violation, because, again, when this patron was brought out, it was because a Littleton police officer was sitting in the parking lot that was observed. And I won't go on ad nauseum, but this is a pattern. and I do have concern. I am willing to, in the penalty phase, go along with what the majority of the board deems proper. But I will tell you with my concerns, if I see the licensee back again, at Uford, we are going to be much, much more aggressive in whatever we do here tonight.
Can I address the point you brought up about the patron? Because we investigated that at depth, and that's not, there's a perception, and I've heard it more than once, that incident last summer where there's something like that a tavern employee had a passed out patron that they were throwing to the alley or abandoning to the alley, and that was not the case at all. The manager got her, assessed the situation, wanted to get her fresh air, got water splashed in her face, and was getting her away from the crowd, escorting her outside when a Littleton police officer walked down the alley. So that the minute the officer saw the distress, he took over, like he should, but never, ever was a patron that was passed out, abandoned. But that's not what happened. And Ms. McCarthy and I, that was her concern when we went through that, and we investigated in depth, and that manager had a situation that he really handled well, and it was luck of the draw that there was a police officer walking just as he came out. So, and I've heard that in another meeting before, and that is really not what happened. But
The only information we had was via the police report, so.
Well, and I don't think.
I appreciate the information, but you understand, I was sitting here,
Sure, I
this is what we
understand.
hear, and we find that, again, incident, because it's outside the tavern, the female patron after hours has gone out there and, again, is passed out, and fire and rescue is called, and she has to be taken. What I'm saying is, from what we have been presented here at the board and what the licensee has expressed to us through council, I do see this as a history and a continuing problem. So,
Thank you.
I appreciate the case you presented. Very good case. Does the city have a position on fine versus suspension?
Well, as I indicated earlier, I would be okay with a fine in lieu of suspension because this is a first offense. What I had encouraged the board to look at is there's a lot of aggravation in this case, aggravation that you can consider under 3214. I think it's appropriate to consider. Aggravation that brings it above the 5 days with 3 held in abeyance with 2 fine in lieu of. And that's why I was asking the board to basically put a bigger hammer, a bigger penalty on them at the same point, allowing it to be a fine in lieu of. And that's why I'd like to see the board get a little closer to the 10-5, but keep the fine in lieu of, so that there may be some additional incentive that this does not happen again. Mr. Beinford indicated somewhat correctly my concerns with the earlier incident of the girl being taken out the back door, and it is correct that the police officer just happened to walk down. One of my concerns in that case, and my concerns in these cases, is the police aren't being called. Why weren't the police called at the time that they found that girl intoxicated within the bar? And it's the same trend that's occurring in these cases. A comment was made about a lot of what I presented tonight being hearsay. Well, everything in the police report is hearsay. Hearsay is an out-of-court statement. We don't have these people in front of us.
And perhaps I misspoke, Tricia, but you also said that those people that you interviewed had other fish to fry too, and could have been holding a grudge against the establishment.
I never said that. In
Well,
fact,
you said that they were in trouble and had to go to court.
they were all in trouble, and they all had pled guilty prior to the time that I had talked to them. They had already handled it, and none of the people, when I talked to them, had any sort of grudge, in my opinion, towards the tavern. They all enjoy the tavern. I would say the comments that were made to me regarding the tavern are very similar to the comments that the authority has made, that they think it is a positive business for the city of Littleton. It wasn't anything that was a grudge. It was just they were stating the facts.
Well, now you're saying two different things to me. One, you're saying that they were out of control and over-serving everybody, and now you're saying that they're a great place. So which is it? I mean, I can't take that testimony to heart as much as the police report, is what I'm saying.
I think, based upon my conversations with them, and I spent a lot of time with these people on the phone, I think both situations are absolutely true. I think they think that the tavern is a good business. I think that night things were out of control and they were overserved and they don't believe it was handled appropriately. A lot of these people are regular patrons of the tavern, and I would say their overall opinion is not necessarily based upon what happened that night. I think it was absolutely fair what these people were saying. I spoke with, at least 6 different people, and in the course of a 30-minute conversation with each and every one of them, I don't think there was a grudge or an axe to grind, and I think many of their statements were very consistent with what they told the officers on that evening. It's just, I spent more time with them than the officers because clearly that night the entire police department was deployed, and they had very limited time with each of these individuals, and that's why I followed up, because there was definitely more information than what was presented in the police report.
Okay.
I would like, at this time, to ask all of the authority members to express their opinion as what is a appropriate penalty in this case.
Excuse me, Mr. Chairman, before we do that, I just want to verify that there isn't anyone else here to testify. I know there's a few people.
I'm aware of that. That's why I'd like to wrap this up. I'll start with my opinion. I'm prepared to go with the 5 days and 3 in abeyance. I haven't made up my mind yet about the fine. I'm open to what others may say, but anyone who has input onto this penalty, I'd like to hear about it at this time.
I am tempted to go with 7 days, with 5 held in abeyance, and commit a fine in lieu of the 2-day suspension.
Anyone else?
I would tend to agree with Earl on that point.
I believe I would as well.
I'd like to make a motion then.
You have that ability.
Based on said finding, I move the liquor license of Tavern Littleton, i.e. the Tavern Littleton, be suspended for 7 days with 5 days held in abeyance for 1 year. And that notice of said suspension be posted in and outside the licensed premises in accordance with the Liquor Code Regulation 47-600F, and the suspension be served on beginning the 24th of January, 2013, and that a fine can be paid in lieu of the 2-day suspension. And I've listened to everything, and considering the case that you have presented is the only reason, and the corrective action that you say you're taking is a reason I'm proposing only 2-day suspension. However, I still want to hold that little hammer, if you will, where you got 5 days held in abeyance for 1 year.
Do we have a second?
Second.
Discussion?
So we're looking at 7 days with 5 days in abeyance and then 2 days suspension, but we're going to have a fine in lieu with the
They could have a fine in lieu. That's up to them. That's their choice.
We would definitely elect for a fine in lieu.
That is the motion,
That punishes the establishment versus the employees, and it's always a great thing to have on a first offense.
I think it's obvious what Earl was looking for here, and that is to push this into the future and more of an incentive not to come back. You're not going to come back and serve 3 days. You're going to come back and serve 5 days the next time. Plus,
it's going to be more.
All right.
Second on the motion?
We do have a second.
Yeah, I agree with that. That'll be fine.
Would you poll the authority, please?
Bradish?
Yes.
Authority Member Gunya?
Yes.
Authority Member Odell?
Yes.
Authority Member Cole?
Yes.
Authority Member Mather?
Yes.
Thanks a lot.
The motion is approved. Thank you for your time. Thank you for your diligence in trying to straighten out your situation, and we wish you the best. We hope you're really successful in not having another night like that.
Thanks a lot.
Thank you all very much.
Thank you.
Next order of business.
No other items on the agenda unless there are reports.
Can I, oh, sorry, is there anything from staff? Can I just ask really quick, on the police officer policy, I know that the policy is that Littleton Police can't serve off-duty as an employer or contractor. Is it possible for police from another jurisdiction to serve?
For instance, Arapahoe County deputy sheriffs.
Right, I don't think there's any problem with that. It's not, it's that our police department has made the policy that they don't want their officers serving.
Yeah.
Right, but I mean, someone from Englewood or.
Right, they could hire Denver
They could
police
hire,
officers.
and they could be in uniform and.
Yeah. They would have to approve that? And would they, or is it? I don't know. Oh.
Okay.
I'm sorry, Kim, what did you say? Oh, okay.
Okay. It just seems to me like if a licensee thinks that that would be something that could help them follow the law, maybe it's something worth looking at. And I certainly appreciate why Littleton officers aren't allowed to, but possibly something we could look at so the licensee can do the best.
Yeah, I wasn't aware of that, the others, so I'll explore that and report
Okay.
back.
Appreciate it.
Just to clarify in my mind, is that a police department policy or is that a city
It's a police department.
municipal rule of?
No, it's not in the code. It's a police department policy. Obviously, it can cause problems if you're in an establishment that then you also have to go in and perhaps write tickets for, but you work for them.
Right.
It can cause problems, or there can be a perception, there can be problems with liability if the public it's unclear whether they're serving as a private security officer, as a uniformed police officer,
Right.
so.
Good question.
Yeah, which, like I said, I certainly understand that, and I don't know if, I don't even know if someone could serve in uniform outside of their jurisdiction, but it's certainly something maybe we should look at. Like you said, if he thinks it would help be successful.
I believe this meeting is adjourned.